yesterday, where we presented this program. So let's go ahead and take the roll, and then Julia Brennelson.
Yes.
Okay. Judge Harper.
Here.
Stephen Hamilton. Not here. And Claudia Torres Ambriz.
Present.
Okay, great. So now we'll see if we have anyone who wants to make public comment. If you do, please raise your hand. Okay. So as I indicated, Claudia is not going to be available to join us until 12:30. And what I thought we could do prior to that time is for me to share, because I don't see Justice Petru on the line, a little bit of the feedback that we got. Oh, here she is, just in time. Justice Petru?
Yes.
Okay, hi. I was saying that our, our main event today is to hear from Professor Pena at UCLA about trauma-informed representation, but she emailed us and said that she's not going to be able to join until 12:30. So I was going to give an overview of the discussion that we had with the board yesterday and some of the feedback, because it was very focused on licensing. So you joined at the perfect time. So why don't you go ahead?
Or you can as well. I mean, I will just say it was my very clear impression, well, more than an impression, because it was said without any question, that there's a concern that we're making the bar for entry too high. That will not only delay matters, but simply, I mean, I don't know how to put it other than the bar is too high. And so I definitely told them that we would be sharing that with the group. They're definitely aware of and appreciative of the fact that our mission is heavily informed by protection of the public, right, of the consumers that would be involved here. But with all of that being said, the bottom line reaction was, this is too much. Leah, what would you add to that?
Nothing. I just think they were, there were some interesting comments about, yes, it's important to protect the public, but we have to think about the paraprofessional as compared to what? That it is not as compared to hiring this amazing lawyer. It's as compared to people struggling through trying to resolve issues on their own.
Or being taken advantage of in many circumstances.
Yeah. So, I think we got a strong message, as was indicated, that, they'd like us to to have you all reconsider if it really needs to be this, the perception was, I think, fairly onerous to become licensed, given that you have to be a JD, an LLM, or certified paralegal to even be eligible. Judge Harper and then Julia.
I was just going to ask, did they highlight any areas? Was it the educational portion? Was it the continuing education? Was it the hours of mentoring that they need to do prior?
I don't think they were so much focused on one particular thing. I mean, they definitely said, wow, that seems like a lot of classes. Hasn't a JD already taken evidence? Hasn't, some of this already happened? I floated the idea that I was very clear that we had not discussed, but that I know that there's been some discussion in this group, for example, that someone could test out if they had taken the course, they could take the test. One question is whether they need to take a test if they took the class within a certain number of years. So for example, I'd ask you all to think about whether if one of these required courses has been taken and obviously successfully completed within a certain number of years prior to the request for licensure, whether that's not good enough. Like, why does there need to be another test on top of that? And there was also definitely a reaction to the number of experiential hours.
Yeah, and a concern that there's not going to be, it's going to be really difficult for people to find attorneys to supervise those hours.
Right, we don't want to set this up in such a way that it can't work. Right. If we get, if people can't get their experiential hours, then we're not going to have anyone in the program. And Leah definitely shared with them the thought of like maybe modifying some things to like how to start incentivizing counsel, for example, with MCLE credits.
Julia.
Well, I know Stephen's here now. Stephen, did you hear the beginning of where this is coming from?
What I gathered was we got input from somebody who had an issue with, it sounds like, the experiential hours and the educational requirements.
It's the Board of Trustees.
Okay.
So we gave an update on just generally the status of the deliberations yesterday. They were really engaged. I was surprised. So I thought it was a great conversation. But definitely was an area of particular focus and concern, I would say.
So, Stephen, it sounds like to me they want us to revisit not only the entrance requirements into the program, but possibly the required courses and maybe even the experiential time. So it sounds to me like we're going to have to go back to the drawing board. My only concern with the experiential is, I mean, I'd have to look back at all our papers and stuff, but I think we had to increase that to even come close to mirroring some of the other programs that have been successful. So if the coursework is, edited to reflect an easier thing, I guess I'm just going to have to say that we're going to have to look at it again and perhaps compare it to the classes again, like with Arizona and
did those,
Canada.
if I could just jump in to ask the question, because I don't recall off the top of my head, those other programs that required a comparable number of hours, did they also require that the person be a JD, LLM, paralegal before doing all this additional work? Because I didn't think so, but I could be wrong.
I don't think they require, I think some of them required a paralegal, others, if I'm not mistaken, there was one that said just a college degree.
Yeah.
Right. So I think that's something that's important for us to look at, is what group of people are we talking about? If it's just a college degree, to me, that makes a lot more sense as to why you'd have more onerous barriers to entry. But if we want to start with people who already have a certain level of legal education, that should probably inform what we're thinking. Leah, were you about to say something?
Just that, yeah, I wasn't, first of all, this is input and feedback, and I think we should be responsive to it, but certainly, the group is fully entitled to come up with its recommendation as it sees appropriate. And we were sort of given the message that there's an understanding that there's a lot more sort of nuance or a number of different policy considerations that are going into these recommendations, and just to ensure that the final report does reflect the rationale for why, whatever it is it's being recommended. But I would say, if you keep the entrance requirements fairly narrow, JD, LLM, or a certified paralegal, then I think it does allow you to say, is there a way for folks to waive out of more of what we've identified? So maybe you don't have to start completely over, but you're a little bit more expansive in ways you can waive out. As the justice said, perhaps if you passed a course recently in law school, then we're going to let you waive out of that entire 3-unit requirement that we're having. So I think maybe thinking about it that way, it would be useful and not require you to completely start over.
I have a question about that.
Mm-hmm.
This is Claudia.
Yeah.
So how quickly does information cycle out in the legal field? Because at the school that I worked at, I was in charge of transferability for the same purpose, to avoid having to test out. We usually take within 3 years, and this is in the art and design field. So does that change as quickly in law? I feel like it may change faster. So that could maybe guide how many years ago was that class taken before it can be considered as a waivable credit choice. Do you all know?
It's a great question. I don't think the law changes that frequently. We used to hear, I think maybe like 300. No, I'm just kidding, but it's like a rap changing field, but others on the subcommittee.
Yeah, I mean, I don't see that the areas that we're concentrating on are going to be, you know, changing radically in a short period of time. But I think that having this feedback gives us a lot of information, because I would say that Steve and I, when we were by ourselves before even Claudia, we were trying to see what we felt comfortable with, but we're also, attorneys with approximately 30 years of experience, and I think it's different for us because we just know what we are now versus what we are when we come out of law school. So I think getting that kind of feedback helps us know that, maybe we are expecting a lot for the rollout of this program. Stephen, I'm going to need some time to reflect on that feedback while looking at our schedule of things. It's correct, Leah, that Stephen and I can't communicate about this outside of the meetings, correct?
We can have peer-to-peer contact. If we bring a third person into it, then we have a problem.
Well, Brady, can you respond? And Claudia is also on this subcommittee.
Yeah.
So, Brady,
I'm sorry, is it just 3?
yeah.
On the subcommittee currently?
Oh, 4. Judge
4.
Harper.
Judge Harper's here.
Yes, we've got 4 people.
Yeah.
So two then would be okay.
2, because I would say that even before Claudia came in, Stephen and I had spent quite a bit of time as lawyers looking at the substantive law requirements. And, then we kind of gave Claudia what we had at that point when she came in. And then later on, Judge Harper came in. So we had really wrestled with what we thought about the subject matter requirements and entry level because of our experiences. But I guess what I was just saying is, if the take on what we have first indicated seems to be too rigorous perhaps, then I think that's good feedback for us to reflect on. I don't know that, once you hear that, you're prepared to just do something immediately. But that's the good thing about feedback, is that it gives you an indication that people who've not been in the meeting with you go, whoa, you're asking a lot of this person who wants to begin this. So having that feedback from the Board of Trustees, I think, is very helpful, because ultimately they're the deciding body, correct?
Yes.
Would you guys, those of you that participated in this feedback session, would you describe their comments as being opinion, advice, or a mandate?
Well, they're not in a position, I certainly don't think they're doing a mandate. We were giving them an update, and it was an open forum for conversation. And as Leah indicated, I'm not quite sure if you were on yet or not, they were quite engaged. They were paying attention and had comments, and I thought it went quite well. And the overall feedback was very positive, and they were glad to see that we were on track, and we laid out how do we get from here to September. So it was overall a very positive update and feedback session. And I don't think anyone was saying this is a mandate, because we also were not saying this is our proposal. We were saying this is what we're thinking.
Okay.
We're very clear that this is a work in progress. And therefore the feedback was not in the form of a mandate, but in the form of this is feeling like too much and too onerous of a barrier for entry, especially given the fact that you're talking about a limited population of people who already have a JD, LLM, paralegal.
So I think one of the things that Julia and I worked on was, it was envisioned that between the education and the experiential, it would take a year to become a paraprofessional. And because you could do the coursework in one semester, and then you could do the experiential in the equivalent of one semester if it was 40 hours a week, 25 hours a week. And we had started at 500 for the practical training or experiential, and it was based on input that we got from Amos Hartson that was just not going to be enough. And that's when we upped it from 500 to 1,000. So
Well, and it's interesting because, if it's 1,000 hours, I mean, yeah, that's 25 weeks, but I mean, that's longer than a semester. What we had put on the slide was realistically, we're talking more like 18 months for people to do this. Because again, there's the concern of who's the attorney they're going to find who's going to supervise, give them work 40 hours a week, full time for 25 weeks.
Well,
And that's fair.
That's always a problem. Exactly. That's always going to be a problem. And it's a problem in our internship classes is to,
And I think that's where also because I think the pilot program is going to be reviewing the education and experiential requirements. That may very be true. There's not enough people out there willing to volunteer that time.
For the paralegals, the way that the recommendation is structured, right? The 1,000 hours over at least 6 months in the intended practice area, they can, if they're paralegals right now and they've been paralegals and that's their paid job, they can count. Will we essentially waive their 1,000 hours?
I think that if they do a declaration, not waive it, but they would be able to enter the program with their experiential requirement met. Because paralegals are working for attorneys, they're probably going to walk in and be able to check that box. They will.
Yeah, much, much more easily than a JD or LLM is. I mean, so really, are we setting this up? I mean, I have to ask the question, really, are we setting this up as a program for paralegals?
well, I think it's more allied with that because they learn many more practical skills than one comes out of law school with. I mean, in law school was not drafting pleadings. I was not filling out judicial counsel forms, those kind of things.
Sure.
And
So
I think was a good point. Maybe the educational requirements. I don't think I'm offended with the ethics or the evidence being dealt with in law school or paralegal school. And again, them being able to check that off if it's within a recent time period. I think we have to keep the trauma-informed representation where it's at. And I think the advocacy and court procedure, because I don't think that that's necessarily something that either the paralegals or the law school students are getting right now.
Well, but what if they did? So for example, I'm teaching a trial advocacy class right now, 3 hours every Thursday night for the entire semester. I think someone who's taken my class or class like that does not need to take that 3-unit course that we're contemplating, because they will have spent an entire semester on what do you actually do in a courtroom.
I think that's a very good point, Justice.
Agreed.
Yeah.
And so it's interesting. So you can kind of think of it as like the paralegal's greatest hurdle is going to be for most, obviously, I'm talking in broad generalities. The paralegal's greatest hurdle will be in getting the courses taken and completed. Someone who has a JD is more likely to have had the courses and is going to be facing the issue of how to get the experiential hours. And maybe we can, sell it. I mean, I do think it's a little too much the way it is right now personally, but however it winds up, maybe we can sell it a little bit to explain the truth, which is that most people are not going to be starting from zero and having to do all these classes and get all of this experience. Most will either, will have a good chunk of one or the other already.
Can we talk a little bit about what court procedure is? And Stephen, before you joined, I explained that Professor Pena from UCLA was not able to join us until 12:30. So she'll be joining us in 9 minutes and we'll turn to that. But court procedure, I remember you were having a really interesting discussion about what is contemplated for these courses versus what's being taught, for instance, in the paralegal program now. So court procedure, what are we thinking that is going to be?
Preparation of pleadings and briefs for a hearing or a trial.
And is that a generic course? I mean, it is in the way that it's listed right now, but I almost wonder, like, I mean, to me, it's almost like court procedure for family is going to be very different from court procedure for unlawful detainer.
True.
Again, different from, like, I almost wonder if rather than that being one of the general ed courses as it's currently listed, that it be actually one of the, a course, but focused on the area of specialization.
Well, that's kind of where we got stuck to begin with, is we didn't know what all our subject matters were going to
Sure.
be, so you could test out of the subject matter, because clearly someone who is just going to be doing expungements probably would not need a bunch of court procedure relative to introducing evidence, etc. So I think those are going to have to be worked on. But this was one of the conversations Stephen and I had last time, was what's the difference between evidence? What was the difference between advocacy and court procedure? And so we had a conversation, and I think we pretty much decided that the first one, we wanted to change the name to pretrial evidence, pretrial discovery and evidence. So it was more about the collecting of the information. Then the second was going to be how to strategize about what you're going to use to get in, and maybe drafting, like he said, the brief or whatever. Now, advocacy, I don't know, I guess, as the final one, Steve, wasn't advocacy the last one? We had pretrial discovery and evidence, then we had procedure, and then maybe a trial advocacy. I mean, I think that's why we need the world of those more defined, so we can see what, if we really need all of those as basic requirements.
So Claudia,
Yeah, that was the
I did
last
end
one.
up- I did end up putting up a slide. I don't know if you can see it on your phone.
No, because I logged on, I called in, but let me hang up and try to dial in with the app, okay?
Okay, you don't, what I just put up is really the one slide, which Julia doesn't have the correction listed for evidence. This is the
Okay.
one slide on licensing that we presented yesterday to the board. So
Okay.
it's not a new presentation. I just thought, since we were talking about it.
Yeah, it shows
Thank you.
the 3 units for ethics, 3 units for evidence, 3 units court procedure, and 3 units court advocacy. And I just think that until we get our subject matters, I mean, I think we were working off of the idea that this was what we were considering for family law, and until we saw the other subject matters, we thought this would work, because to be honest, I think it's going to be very difficult to hire professors at different colleges if there's going to be only one class on this and one class on that. It's a lot of startup time for the professor. So we've got to keep that in mind as well. But I do think that in terms of defining the scope of what the student learning outcomes would be of each course or each area of study would be helpful in us drilling down to see if we can't eliminate or at least modify some of these.
Or allow people to waive out.
Yes.
Because it sounded like maybe if you've taken trial advocacy in law school, which not everybody does, but if you take it and you pass it, then maybe you could waive out of court advocacy.
Stephen?
Yeah, this question might be better for Brady. So I remember that they reviewed my transcript from Hastings to determine what credits I was going to get or progress I was going to get towards the law office study program. Is there somebody within the bar that reviews transcripts to determine transfer of credits from other institutions or other programs?
I'm not aware of that, Leah. Do you know?
Yes, it is. It's in the Office of Admissions. So it's for all kinds of different things. We do that foreign students. It's mostly like foreign educated students and seeing the admissibility of their classes. But yeah, there is.
I think if we contemplated that there would be somebody within the bar that would be reviewing the course transcripts to confirm that the student that completed Justice Petrew's advocacy program, that met the requirements of our court advocacy requirement, as it just opposed to being perfunctory, here's my transcript, give my credit. I think I'd be really comfortable with pretty much all of the educational requirements being satisfied through either your law school or paralegal education.
So then what you're saying, Stephen, because see, we have to think about the procedure as well, is that what happens, for example, when you come to take paralegal classes where I teach is, say you don't want to take some of the classes because you've taken them in other institutions. Well, if they're not ABA approved, many times we don't get approved that they, and require that they repeat them in our college. And so I think, the thing it would be bad is if a person thinks they have trial advocacy and are not going to have to take court advocacy, they finish what they think is part of the program, they then submit their transcript and they find out it's not going to be accepted, then they got to go back to school and do the court advocacy. See what I mean? So I think we have to think about this too, is at what point would the state bar review process get involved? Because I know it's hard enough just getting folks reviewed to come into a paralegal program. But if this is going to be something that's going to include the college acceptance of the student, the bar's acceptance of the student, and they could be later on that they find out their previous work did not get accepted, I can see how that'll be just stumbling.
Yeah, I'm thinking that it might be kind of like the law office study program, meaning the first thing a prospective paraprofessional does is register with the state bar. And then there is the review of the transcripts, some decision is made about what you have to take. I mean, it could be affirmative, and that is something that then the student takes to the community college, if that's the program, what we have in place. So that might be the cleanest way to work this.
I think you're right on, Leah.
But let's go back to, could you waive everything? Because I do think there's such a different law school. To me, it was just so theoretical. I did not walk out of there feeling like I could actually do anything.
So they're changing it.
So I do feel like there's something about having some coursework, and maybe that's just not the case for paralegals, but
you know what, Leah, I have to say, like at Berkeley, it's amazing how different the course offerings are now as compared to 10 years ago, let alone 20 or 30. It is completely different, right? So like when I went there, there was very little practical. There was probably some more when you went there. Now you can take a specific course in negotiating a kind of deal. You can do, I mean, there is like a plethora. There are dozens of courses that are very practical because of exactly what you identified, which is you walk out of law school without having any idea what you're doing.
Okay.
And so I do think that if people are actually taking these courses, then they're getting that experience.
So so now when you take evidence in law school, there's some element where you learn actually the mechanics of submitting evidence.
Not so much, but there are a lot of practical courses that involve how do you submit evidence, right?
Okay.
So for example, in my trial advocacy course, part of it is how do you get in exhibits? Like, right, when you're actually questioning people, like, how do you actually do this? How do you physically get an exhibit marked? How do you get it into evidence? What are the requirements for laying a foundation? Like all of that stuff. But it's really, the law school classes, in my experience, have expanded dramatically towards the end of practical experience in the last 10 years.
I see that Professor Pena has joined us. So what I want to do, she's over in the attendees. I want to move on to her, if you don't mind, to be respectful of her time. And if we have some time at the end, we can come back to this and also just figure out what our next steps are on this particular topic. So let me, Professor Pena, you're on mute. There you are. Hi.
Hello. That was a fancy transition.
Oh, good. Glad to hear it. So thank you so much for joining us. And hopefully Linda was able to give you a little bit of background about what we're doing and why we reached out to you.
Yeah, I did get a little bit of background via email.
Okay.
Anything else you'd like to share? I'm always happy for more information.
Sure. Well, why don't we just do a quick round of introductions, and then maybe one of the subcommittee members can tee up asking you to do an overview of your course. I'm Leah Wilson. I'm staff to this subcommittee. So maybe Julia, you could start.
Hi, I'm Julia Brynelson. I'm an attorney, but I'm also a professor in a paralegal college, American River College in Sacramento. And we're, I think, the only ABA approved paralegal program in Northern California outside of the Bay Area. So we reach many, many students in Northern California. And I've been teaching there for 14 years and I've taught 14 different courses.
Excellent.
Judge Harper, I see you next on my screen.
I'm Judge Harper. I'm up in Trinity County, so other part of the state, and just trying to participate and hopefully give some insight. From a really small county, we have only about 15,000 people in our county, so going to bring a rural county perspective to things.
Claudia.
Hey, everybody. I'm Claudia. I'm an artist, an educator, a member of the public. Yes.
But on the subcommittee. On the
subcommittee,
working
yes.
group.
I am on the working group. I am also a member of the public.
Okay, Brady,
Sorry.
you're on mute, Brady.
Hi, Claudia. It's been 10, 12 years. Claudia and I were a year apart in law school. Yes, hello.
Oh, wow.
Your
And we
hair
had
looks significantly different.
It's different. A lot grayer too. Claudia and I were a year apart and had a very close mutual friend. Anyhow, I'm a assistant general counsel here at the bar, and I'm working with this working group on legal issues. So nice to see you.
Fun. Stephen.
I'm Stephen Hamilton. I've been an attorney for 26 years, primarily family law, a certified family law specialist, fellow in the American Academy of Matrimonial Lawyers. I'm in Arroyo Grande, California. You getting rain today? Because we're getting it here on the Central Coast. A little bit, that's what we're getting to. And I'm the representative from the California Lawyers Association, which is the quote unquote trade association when the bar became segregated.
Segregated. That's not a great term.
That is the term they use in other jurisdictions, Leah.
Oh, okay. All
Yeah.
right. Justice Petru, are you here?
Yes,
Okay.
my name's Ioana Petru, and I am not on this subcommittee, but I chair the working group. I'm on the Court of Appeal in the First District, which is up in San Francisco, and I used to be on the trial court in Alameda County.
Great. And Sharon is our very capable admin assistant. So that's who you've got here on your screen. And I don't know, Stephen or Julia, maybe I think you would be best to tee up Claudia and what we're hoping to hear from her today.
I'll let Stephen do that.
Okay, so you can blame me for having to be in this meeting today because we were contemplating that at least in the area of family law, that paraprofessionals should get a 1-unit course on trauma-informed advocacy and representation. So what did I do? I Googled to see which law schools were teaching a trauma-informed program, and that's what led to you. And it's not just, we're not anticipating just family law, but we want the paraprofessionals to have some education, trauma-informed education to assisting the potential clients in any of the areas that we're contemplating, like housing, collateral criminal issues. So they're sensitive to that. And we were looking for a program that's already teaching it to figure out what should we include in the program. Is this something that you think either or at both a paraprofessional, at a paralegal school or at a law school could be taught virtually? And just get any of your thoughts and ideas on whether you think this is a good idea to include this, and if so, is 1 unit sufficient, and what can be accomplished in 1 unit? Is that fair, Julia?
Yep.
Okay.
And just generally what you're what it is, what you're teaching.
I just want to make sure I'm noting everything that I heard. I love all of these questions. This is my favorite topic. Okay, great. So let me start off. I'll just chat a little bit about what I do and how it came to be, and then answer Mr. Hamilton's questions more explicitly. I went to law school with Brady, 2005 to 08 at UCLA. And I had an interest in trauma-informed practices before I attended law school. through things that happened with my own family. I got interested in research around it. And then I served as a director of student diversity programs at Mills College before going to law school. So through the campus-wide programming I created, much of it was around trauma-informed practices and addressing trauma in vulnerable communities. So when I got to law school, I was so surprised that we were interviewing clients who had experienced severe trauma and had no training on what interviewing practices should look like when working with vulnerable clients. So post law school, I co-founded an organization called Repair with one of my colleagues from UCLA, and we developed trainings. And I'm sure as you were doing your research, Stephen, that you saw that there are not very many law schools that have a trauma-informed legal course of any sort. In fact, when I first developed the course years ago, there had only been 4 law schools in the entire nation that offered a course at some time, one of which had offered it once. And it is my position that we actually have an ethical responsibility to be trauma-informed, because we cannot practice good communication, diligence, or competence without being trauma-informed on some level. So through that organization, when we created the trainings, I was doing them for working attorneys at that time, the federal public defenders, and numerous organizations in the immigrant legal services area. That first year, I can't remember, I think I did maybe 10. And at every training, people would come to me afterwards and say, where was this when I was in law school? Everything would be so different right now if I had known all of these practices, because I see trauma-informed lawyering from 2 perspectives. One is incorporating what you've learned in order to understand your client more and understand your own legal strategies more. The second is addressing your own vicarious trauma that you experience as a result of bearing witness to so much of what your clients are sharing about their lives and their experiences. So out in the practicing world, training attorneys, when they would hear when they would see the different options they had with which to approach and pursue their own legal practice, they were very upset that they were 10 years in, feeling very burnt out, feeling very affected by their work, and they wish they had seen it, or they wish they had learned it when they were in legal training. So then I got the idea of putting together a course. I already taught disability rights law, and I had a whole trauma-informed lens to it, but I figured putting together an entire course would be a better idea. And so I started doing trainings for students, and little by little that became an entire course. What does it look like? There are some law review articles on trauma-informed practices. In fact, the first one I think was written in 1990, 91 by Sarah Katz and others. But of course, the research and the science has changed a bit since then. So there's more information now. So the students do a lot of reading on what trauma is. They get education on the neuroscience of it, what happens in your brain when trauma has been experienced. They learn about the manifestations of trauma and what that looks like in your client. And then they learn how to address them. If your client starts to have a panic attack, how to walk your client through getting grounded again. So there's various manifestations of trauma. Sometimes your client is exhibiting a few of them at the same time. And it's my perspective that lawyers should know what to do in those situations. So that's what the course looks like. To answer your question around which topic areas might benefit from having this education, I spoke on a podcast fairly recently where I was saying I think everybody in the whole world should be trauma informed. So there really isn't a legal area that I think wouldn't benefit from it. In fact, I often get hired by firms who are having a really hard time working with their client because their client has experienced so much trauma and they know that their approach isn't really working. So they might bring me in to help with communication. And there was one time where I worked with someone who was an IP client, whose IP had been stolen from him, from someone that he knew for a really long time, who was really dear to him. And it was very clear to me that he was very traumatized by the entire experience. So it's not just the sort of obvious criminal legal system, family law, immigration. Trauma can be experienced in any type of case, on top of which sometimes your client has experienced trauma with something not having to do with their legal case. And it's still imperative that you communicate with them in a way that doesn't re-traumatize them and that mitigates the effects of the legal system on their experience. Because what we hear over and over again is that the legal system is pretty traumatizing in and of itself, right? As a result of it being the adversarial system, when people come into it in a vulnerable, from a vulnerable place, just the fact that it's an adversarial system, it can be really harmful and painful for people. So understanding that your client may have experienced trauma outside of their legal issue and that trauma exists in lots of different legal issues, it's my perspective that any legal area would benefit from this training. To answer your question around the unit, I don't know because I don't know how units work in this educational system. Can someone share a little bit with me about how units work, like how many hours that means, how much class time, that sort of thing?
I think we've decided if it's one unit, it would be about 16 hours.
Yeah, one unit sounds, I mean, you know, I wish we were all talking about it all the time. I get greedy when it comes to this kind of this topic, but 16 hours, there's a lot that can be done in 16 hours.
Do you include compassion fatigue in
Absolutely.
your okay. Do you think that that could be still incorporated in a 16-hour classroom with the understanding there's probably 32 hours of out of class work going with it?
Yeah, compassion fatigue is a huge part of it. And that's part of the vicarious trauma. Compassion fatigue is one of the, it's like one of the vectors that leads to vicarious trauma as you continue to experience compassion fatigue. So yes, it's incorporated. It should be incorporated. You can't teach it without it.
Perfect.
Was I responsive to everything?
Mhm.
You did a great job.
Well, I have a question. So UCLA offers a course. Are you the only school in California that offers this course right now?
That I know of. My understanding is things are shifting right now as we speak. So if you had been around UCLA for the last 6 years, you would have been tired of seeing my face and tired of hearing me say, we need to normalize this in all of legal training. Everybody should be talking about it. I don't want to be the only one that gets called to do these trainings or teach these courses. Please, everybody talk about it all the time. It was me and like 3 other people maybe in the nation talking about it at the time. My understanding is more and more folks are talking about it. In fact, the ABA, and maybe Julia knows more about this, there are 3 or 4 people working together, including a colleague friend of mine, that are putting together a trauma-informed lawyering sort of course book, but through the ABA.
Mm-hmm.
They just got contracted to do it, so I don't think any writing has begun. I couldn't agree to be one of the writers, but I did say that I would edit a section.
Yeah. And I would say through my family law trade associations and groups, there's always at least 3 or 4 courses that may include trauma-informed education. And every once in a while, or maybe once a year, it's specific to trauma-informed advocacy. But the CLE is out there, but in terms of a fun, an initial course, it's not. The only one I could find was the one that Claudia teaches at UCLA.
I was hoping to, at some point, put together a course book so that it would be taught at lots, so that it can proliferate and be taught across law schools. Alas, there are only 24 hours in a day.
Yeah, I'm getting a little nervous because I'm thinking that we're probably gonna need to call on you to develop our curriculum, and we'll see if you have time.
It's important. I mean, this is exactly the kind of stuff that I would want to spend my time on, is anything that helps it proliferate, right? And where other people feel like they can be the ones teaching and training it, where they have enough information to do it. This is what makes me really excited. And I'm noticing there are 2 judges on this call. These trainings should exist for judges too.
Well, one of the people who actually alerted us to try and include this was Judge Yu. And so she's the one that introduced this idea for us. Can I ask you, Claudia, how many courses do you teach then at UCLA, and how many units are they?
At the law school, I only teach 1 trauma-informed lawyering course a year, and it is 4 units, I believe. And this is I'm in my 4th year. I also teach classes on trauma-informed practices, trauma-informed advocacy through the gender studies department at UCLA as well.
Okay.
And I have to tell you, teaching undergrads is so much more fun.
Yeah.
Yes. They're like light bulbs are everywhere. They're so excitable. They can like integrate the information so quickly. Whereas my law students, it usually takes me a week to 2 to get them going. They start off like this. But then by the end of class, they're like, this was the best class ever. Everybody needs to take this class. I'm like, I know, you should have shown up in week 1 with that energy. You know how much you missed out on?
And is it a mandatory? It's not a mandatory class, is it? No, okay.
No, but each student that's taken the course has gone to the administration and said, this should be a mandatory course.
Yeah.
Yeah, making classes mandatory in law schools, as you know, is really, really difficult.
Okay. Any other questions for Claudia? All right, thank you so much for your time.
Thank you very much.
Exciting. Thank
Very
you.
welcome. Glad y'all
Very
are having this conversation.
All right.
Trailblazers.
Okay.
Great to see you.
Good to see you too, Brady. Take care. Bye, everyone.
Thank you.
Bye, thank you.
Had you made that connection, Brady, before the call? I mean,
Um,
like the mental
you know what?
connection?
I'd heard the name Claudia Pena, and I'm like, because we weren't close. We had a close friend in common, and I think that was her last name, and that sounds like something she might have gotten into. But it was actually this morning that I finally looked her up. Oh wow, that is. I saw her picture on the website. That is definitely her. So
Fun.
yeah.
All right, so that sounds doable, and it sounds like maybe if we happen to get any paraprofessional program applicants from UCLA Law School who didn't pass the bar and took that class, they could waive out of our requirement.
Yeah.
Yeah, that's another one you could waive out of. Yeah. Okay. So we have a little bit more time. It sounds, like I think we thought we were kind of done with licensing for a while until each of the remaining practice areas was finalized. Now I think based on this feedback that we got, I think the task is to identify more options for waiving the requirements. That might be a place to start as opposed to changing the requirements in the first instance. And Julie, you've been consistent in talking about needing to, I think, specify the learning objectives for each of the course requirements, just to make sure like we're really clear on what it is that we think folks need to get out of each of those blocks of unit requirements. But why don't you guys tell me how you want to proceed? What?
A quick question.
Uh-huh.
So I know that the JD, LLM, or a paralegal degree or license is a prerequisite. It sounds like some other states don't require that. So is that something we've already decided on, that we want that for California no matter what? Because then I think that's easy to move on from that to say, okay, then we can do the waivers.
We had pretty much decided that's who we want, especially to start out the program. We wanted folks that came with, some background and education in the law, so that we weren't facing just taking, an English major from college and trying to develop them within a year to do this kind of work. That was our fear. We felt more comfortable. I mean, the only other people we considered were the Masters of Sciences in Law, and we decided they were not applicable because it was just, again, it wasn't really, it was information about the law. It wasn't as specific, let's say, as one who might want to practice law or work as a paralegal. So at this point, we did so much work on, we even were, not even going to allow the entry of, what was it, Stephen, registered California Law School graduates until we found out they were passing the bar at the same rate or better than the others. So we've spent a lot of time on that. And at this point, I'd be more interested in seeing how we could, like Leah says, wave through some people, and then, we will take stock of it. But I think if we know that we're all going to have this group of people who come with, because what I said to Leah was this, is if that English major really wants to do this program and can find out that they can go to paralegal school and become a paralegal in a year, then this only ends up being some additional work for them. You see what I mean? But let the paralegal school do the fundamental work for them and not us.
And my concern would be if we were to lower the threshold to just any college graduate, we're losing so much of the law specific education, whether they took the law school track or the paralegal track. I would think then there need to be looking at a 2-year academic program. And now we're increasing the burden and we're being inconsistent with the advisements, at least that Leah and Justice Petru got when they talked to the trustees.
And it does, I mean, it automatically then kind of does become a 2-year degree for that person, because like I said, they could probably get done with paralegal school in a year if they really worked at it. So I mean, but that wouldn't be our responsibility.
Sure. So knowing that, then there is this legal foundation they already have. So the ability to waive out or test out, I think is very practical.
Far more comfortable with that if we know that they came from either a paralegal or a law school background.
Yeah.
And again, I think it's better if we have, I think it is better if the threshold and the bar is set higher to start off with. Easier to scale back than to increase the requirements down the road if that's what the pilot program reveals.
Sure.
Well, and I think in the presentation of either an executive summary or in how it is presented to the Board of Trustees, having that same information that I just discussed with Judge Harper is the idea of, don't look at it as such a large obstacle. This is how they can fix that within a year's time. There is a remedy readily available. And that, so they can just get in an additional year. It doesn't mean that they're being forbidden from entry. It's, you have to do one additional step and then you can go in.
No, I think it makes sense. And I think it's in the JD, it might be someone who didn't want to take the bar, didn't want to go the law, but decides this is an area they still would like to participate. They don't lose that educational background. They can waive out of courses they've already taken within a certain period of time or test out so that they're more available to be ready to go.
Yeah.
Okay.
So I think we're going to start with the same group of applicants, the same population of applicants that we decided on. So the real work, it looks like Leah is going back to the courses.
Yeah, I think so, because it gets to what is the equivalent course that allows you to waive the requirement. And in the alternative testing, which there's a lot of reasons not to do it, but the one reason to do it is it's a lot easier to administer than like a waiver program where you've got to review transcripts. And I say that because well, we had that little exchange about law school teaches you a lot more practical things now. If we have a requirement for pre-trial discovery and evidence, which I think is what that unit requirement is now, and let's just say you took evidence in law school, which you have to take evidence in law school, but it's not the evidence in law school class that's become more practical. It's another class that you can take on a voluntary basis that would allow you to waive out of pre-trial discovery and evidence? Or is it simply, if you took evidence in law school and passed it, you waive out of the paraprofessional program requirement? If you see what I mean, I think the learning objectives have to be delineated for these paraprofessional courses so we know what allows you to waive out of the course.
Well, and I think a starting point, for example, with Justice Petra would be if she could share with us, if she didn't mind, her syllabus, including the learning objectives. So at least we know we could look at that for trial advocacy. And then perhaps we could look at some others, because I mean, even as we found with ABA approved programs for paralegal, I doubt the ABA, well, I'm not sure, I shouldn't say I doubt, but just like we are not required to be very, very specific that every ABA approved program does the same thing or offers the same courses. I don't know what the universe of requirements are for law schools, but I would like to look at them and then I'd have an idea. But I think for me, at least from the trial advocacy course, if Justice Petra wouldn't mind sharing that with us, that would be wonderful.
I mean, my only concern is I presume that if I share it, then is this then part of a public record somewhere?
Oh,
I guess so.
Yeah, so I'd rather, I mean, I can tell you, I mean, I'm reading my course description right now. This course teaches the fundamentals of trial advocacy using a law, a case file, While it focuses on the core skills of witness examination and opening and closing statements, students will also be trained to hear and make evidentiary objections, introduce exhibits into evidence, prepare for trial, and identify ethical issues. This is a learning by doing class. Each week, students perform assigned trial skill exercises. Fellow students act as witnesses and opposing counsel. And then, there's a whole list of what's required every week, starting with, direct, cross, open and closing, but then things like the use of exhibits is incorporated throughout. And how do you identify them? How do you lay a foundation? How do you introduce them? I mean, this is a fulsome, and I'm not the only one. There are a lot of these courses. It is a complete trial course to teach you what you're doing from the outset through the end.
So clearly that would exceed what, that's going to exceed what we were contemplating or be at the same level. So clearly any of your students would be able to bypass or check that box for that advocacy course. I wonder if it's like, how difficult for us would it be to identify the paralegal programs or law schools that teach a program similar to Justice Petru's that we could cite and say, these are institutions that if you took trial advocacy at these institutions, it'll satisfy this requirement.
Well, you're not going to find those at paralegal schools because they can't practice law, and paralegals can't practice law. It would only be law schools.
Right.
And,
Judge Harper, you've been so
So I
kind.
had a quick question is it contemplated that, so I think I want to be a paraprofessional. So do I go through a program thinking I want to be a lawyer, I'm going to go to law school and maybe I take the bar, maybe I don't, but are we contemplating registering through the state bar for a paraprofessional and then I go get these requirements? So am I going to sign up beforehand knowing I'm going to go into be a paraprofessional, or is it something I'm going to go through the program then decide to do it? And that's what I'm sort of, is it contemplated either way?
That's a really good, I've been wondering this is Joanna, I've been wondering the same thing, because ultimately it would be really nice that if someone, for example, someone who's contemplating going to a paralegal program, right? Would have the option that there'd be a paralegal track and a paraprofessional track, and that they could make that decision at the outset.
Exactly. Yeah.
So personally, I think it would be great if, as part of our initial proposal, sure, we're looking at JDs, LLMs, paralegals. That's for now. I mean, certainly it would be, I would think, fantastic if that expanded to there being paraprofessional programs. I think most likely in conjunction with the paralegal programs that someone could opt into from the get-go.
Yeah.
well, Leah, can I speak to that, kind of like with what I sent to you about the pathway?
Yeah.
So, we were talking, I guess, with community college, and, there are the new pathways to law. And what I look at this as is another option. So in my opinion, when folks, and in my experience teaching in the paralegal program, I receive candidates who went to law school and either didn't make it through law school, they didn't cut it, or they could never pass the bar. And so they come to paralegal school to get their certificates so they can still work in the law. So I guess this to me is a person that is either someone, once they get through paralegal school, could say, I can do more than this. I want more independence. This is what I want to do. You see a lot of that with legal document assistants. They want to be entrepreneurs. They want more possibilities. So I look at it as something that, yes, can be chosen from the outset, but I also see it as someone who had a dream to become a lawyer, worked very, very hard at it, and could not accomplish it for whatever reason. And they see this maybe as a default, but I also would see it as another way to make them very important in the legal profession because they are filling the justice gap with the type of work they'd be doing. So I think I would like to offer it almost as like another pathway. And you can either get there from wanting to join it in the outset, or you get it because it's an alternative to being a lawyer because you're struggling and not able to be successful at that.
Does that answer your question, Judge Harper?
It does. It's just, because I think it changes the focus on, and then who do I apply to then to get waivers? Who do I apply to test out? And if I'm thinking that's the route I'm going to go.
Yeah.
I think it's going to have to be the state bar, like Leah said.
Yeah, I think so.
I think so too. Okay, so I have a to-do to try to get course outlines. Where I'm thinking we might be able to get this is from California accredited and registered law schools, because the state bar itself is the regulatory body for those schools. And on a regular but not frequent basis, there is a recertification process that involves looking at precisely these kinds of things. So I will reach out to the Office of Admissions and see if we have anything like that. We don't have any jurisdiction over ABA law schools. So and for paralegal programs, the best we might get, Julie, is what you have at your program. Like, I don't know that we're gonna, we might have to say, this is what we could get access to, and based on this review, this is what we understand the courses to comprise at law schools or in an ABA paralegal program, and then take it from there.
Mhm. Well, and I see Ira's on this call as a member of the.
Yeah, Ira, we can call on Ira. We can.
And if I can just chime in on we were talking before about what's currently available and how there are a lot more experiential classes available. I'm more familiar with the ABA schools as far as what is actually being offered. What's not offered, as far as I know, unless someone has worked in a clinic, and there are a lot of students who work in, for example, housing clinics, domestic violence clinics. So those students have the experience, but unless they've worked in clinics, what they're really missing is, what are the forms? How do you fill them out? It's that lack of knowledge, it's the lack of familiarity with the judicial council forms.
Yeah.
Also, because the ABA accredited schools tend to focus much more on federal practice rather than state.
Yeah. No, and it came up before, even the concept that there are also local rules.
Right. Which is what I was talking to my students about last night. Local rules, and then the, local courtroom judge rules.
Yeah. Yeah. Okay. So I want to figure out how to, I will work, and I thank you for reminding me about Ira, so we know we can get something from Ira. But I will work to try to get these course outlines together. And then I do think it's a matter of taking pretrial discovery and evidence, court procedure, court advocacy, and mapping out, what the learning objectives would be. And then we can start to see, okay, what would waive you out of this?
Right.
Okay. And is that something that the four of you want to do? I mean, I do think Judge Harper's would be really valuable for that, which means it's still like a public meeting.
That's fine. I mean, as long as everyone in the meeting knows it's
The work session.
that it's going to be, that kind of a meeting, and not as entertaining as today was. It's going to be nuts and bolts of looking at a lot of things. Yeah, I think we'll have to have those with a few days in advance of the actual meeting.
Yes. So I'm sure we have another meeting set on a very quick timeline, as we always do. But realistically, I think we'll need to let me see how much time it's going to take to pull this together, get it out to you, and then maybe, so we might skip our next meeting, and it might be for the meeting set after. Again, I'm not looking at the dates right now, but usually we're meeting every week.
Right.
Next week, or next meeting's next Wednesday, I believe.
Yeah. Okay. So I won't have all this to you by next Monday, so you have it a couple days in advance. So why don't we plan on not having that one next week, and then meeting the following week, and I will pull together as much as I can by then.
Perfect.
Okay.
So we're canceling the next Wednesday
Sounds
meeting.
good.
Yeah.
And I think we may have the one for the next week already scheduled.
Oh, yeah, I'm sure we do. I have so many of these on my calendar, as I'm sure you you all do, and I can't immediately see which they are.
The 10th, I think, is our next one after.
Oh, we have a
Yeah,
whole week
so
off.
we don't have a meeting scheduled for the first week of February. So if you wanted to push January 27th to like the 3rd, I'm available, or the 5th. I could do February the 5th if others could. I just don't know what your availability is.
If we did it, we would have to notice it today, right? For it to be 10 days in advance.
12, yeah, well, yeah, because the 10th day would fall on Sunday.
Yeah. So can you all do the 5th? I think that would be better than waiting.
I could
The
do
5th?
The
3rd.
5th at 12 o'clock again?
Yeah.
Okay, I can probably do it, but just, I am a contract laborer, so sometimes I'm not able to suddenly, but I'll let you all know as soon as I am able to tell you.
Okay. So why don't we go ahead? Sharon, are you hearing this?
Hi, yes, I am.
Okay, so if you could go ahead and get that notice taken care of that we'll cancel next week, and then we'll notice Friday, February 5th, 12 to 1:30.
So I thought you were talking about doing it the Wednesday the 3rd. So
No, the 5th.
Sharon, you technically have until, I guess, Tuesday to get the notice posted, but no reason not to today if you have time.
Okay, thanks.
All right. Thank you all.
Thanks, everybody.
Have a great weekend.
Thank you. Have a good weekend.
Okay, bye-bye.
Thank you.
Bye, everybody.
Bye-bye.